Very warm good evening to all. Today first we will discuss section 25 of the Hindu Marriage Act. The popular section under Hindu Marriage Act is section 24, being an interim maintenance, which is too common and too popular. So every lawyer who gets a wife as a litigant, mostly 24 is gender neutral, anybody can apply, but mostly we see that section 24 is used by the litigant wives to get the maintenance. This is the most important, and many times it decides the fate of the case also. If interim maintenance is higher, then possibility of settlement is early, and if interim maintenance is low, then also it may drag on. But there is one more important section under Hindu Marriage Act about the maintenance, that is section 25. Now, very few people use this section. The reason behind it, it's not known to everybody, but it's mostly at the conclusion of the trial of the Hindu marriage petition. Now, what we are supposed to do, that Hindu marriage petition, whenever you apply, you can always make a prayer in the petition itself about the section 25. So we always make a prayer for section 24, but we never make a prayer for section 25. So when you apply for divorce, or you are applying for restriction of conjugal rights, or you are filing a written statement, in that also you can always request for section 25 of the Hindu Marriage Act prayer. Now under this section there is a permanent alimony. Now to get a better clarity on the section 25, we will read it. Permanent alimony and maintenance. Now this is subsection 1 of 25. Any court exercising jurisdiction under this act may, at the time of passing any decree or at any time subsequent thereto. See, the wording is at the time of passing any decree, that is the conclusion of the trial, or at any time subsequent thereto, and on application made to it for the purpose by either the wife or the husband, as the case may be, order that the respondent shall pay to the applicant for her or his maintenance and support such gross sum. See, gross sum, it may be a lump sum amount, or such monthly or periodical sum for a term not exceeding the life of the applicant, as having regard to the respondent's own income and other property, if any, the income and other properties of applicant. See, there are three parts to this. One is at the conclusion of the trial, that is at the end of the end of the trial, we can say. Secondly, it can be made by husband or wife, that is gender neutral. Even section 24 is gender neutral. 25 is also gender neutral. Also, it will be a gross sum, maybe lump sum or monthly or periodical sum for a term not exceeding life of the applicant, till the applicant is alive, as having regard to respondent's own income and other properties, if any, the income and other properties of the applicant. The court weighs the both sides properties, who is owning the property, the conduct of the parties, and other circumstances of the case. It may seem to be to the court to be just, and any such payment may be secured if necessary by a charge on the immovable property of the respondent. Now, this was the first one. Now, if you read the second part 2, if the court is satisfied that there is a change in the circumstance of either party at any time after it has made an order under subsection 1. Now, 25(1) is during the pendency of the divorce petition, that is at the conclusion of the trial, because the case is going on. The Hindu marriage petition is going on. The MP petition is not concluded. Now, the part 2 is if the court is satisfied that there is change in the circumstance of either party. Suppose divorce is granted in the year 2000, and 2004, the wife who has not remarried, she wants permanent alimony. She can always go and ask under subsection 2. If the court is satisfied that there is a change in the circumstance of either party at any time after it has made an order under subsection 1, possibly there is the court may have granted only interim maintenance, which has continued as a section under section 25 also, which was 3,000. In one of my case, 3,000 was granted about 14 years ago, and that the lady came to me, and he was irregular in paying that meager amount of 3,000 also. So I again went to the court not for enhancement or for execution. I filed under section 25. Of course, the opponent fought with me tooth and nail. But what happened that when I put up the condition, the daughter has become now about 17 years old. She is going to college. She needs money. Secondly, the petitioner who got divorced few years back is much more better position. He has properties. Thirdly, the wife is not in position to look after the daughter in a complete way. In financially she can't support, and for daughter's sake he has to give. So under section 25 there was some settlement, and some amount was in lakhs, some amount was given to that lady. Otherwise under section 25 we can always ask as per the property of the opponent client here. So section 2 is after divorce petition is allowed, and after some is the client comes to you, or after whatever time, after even after 1 month you can go. And about the section 125 subsection 1 is during the pendency. Always remember this, but at the fag end of the trial. Now next condition, if the court is satisfied that either part, that the party in whose favor an order has been made under this section has remarried, or if such party is the wife, that she has not remained chaste, or if such party is the husband, that he has had sexual intercourse with any woman outside wedlock, it may at the instance of other party vary, modify, rescind any such order in such manner as the court may deem just. Now this is to be understood in a different way. Suppose there is an order of 20,000 per month while granting divorce, and the wife remarries, then this section will come to the rescue of the husband under subsection 3 of the section 25, that that whatever amount was decided, if the wife has remarried, then this amount will not be paid henceforth, but from the date of marriage. Secondly, it is possible if it is a husband, which is very rare in such kind of cases, he had some sexual intercourse outside with some other lady, and they also there is a possibility the wife has not remained chaste. In those cases also it is possible that this the court may rescind or cancel this maintenance. So these all these three sections are very important in the Hindu Marriage Act, that is subsection 1 to 3 section 25. So it is one of the, I would say, pillar of the Hindu Marriage Act, which is very rarely used. We should use section 25 as we use section 24. So if we know section 25, it will really help so many clients of us who has actually not got maintenance as per the condition that time prevailing, and he or she was unable to bring the true position before the court. So sometimes clients come later on that this has passed, and now I have found out he's working, or he is working in a better condition, he has got properties. So section 25 can be used later on, but then you should be aware about this section. So section 25 is as important as section 24. Now I'll go to next segment. Ekta will be reading today. Ekta, kindly unmute yourself. Just a minute, I'll be sharing with you.
Yeah.
This is a very beautiful piece related to matrimonial dispute. Recording wife's telephonic conversation without her knowledge is infringement of privacy. Punjab and Haryana High Court. Ekta, you're going to start reading from here.
Good evening, ma'am, and good evening all. We'll start. Chandigarh, December 13. Recording of a wife's telephonic conversation without her knowledge is infringement of her privacy, the Punjab and Haryana High Court has observed. The Court of Justice Lisa Gill passed the order last month on a plea filed by a woman who challenged a 2020 order of the Bathinda Family Court. The Bathinda Family Court had allowed the woman's estranged husband to prove a compact disc pertaining to recorded conversations between him and his wife, subject to the condition of its correctness. Recording of telephonic conversation of the wife without her knowledge is a clear but infringement of her privacy, observed the High Court. Furthermore, it cannot be said or ascertained as to the circumstances in which the conversations were held or the manner in which response elicited by a person who was recording the conversations, because it is evident that this conversations would necessarily have been recorded surreptitiously by one of the parties. It further observed. The husband has submitted a petition in 2017 seeking a divorce from the woman. Their marriage was organized in 2009 and the couple had a daughter together. During cross-examination, an application was moved by the husband in July 2019, seeking permission to submit his supplementary affidavit by way of examination in chief, along with the compact disc and transcripts of conversation recorded in memory card or chip of the mobile phone. In 2020, the family court allowed the husband to prove the compact disc subject to the condition of correctness, and also observed that strict principles of evidence were not applicable to the proceedings before it. Keeping in view Section 14 and 20 of the Family Courts Act 1984, thereafter the wife approached the High Court. The counsel for the wife argued that the evidence sought to be led by the husband is completely beyond pleadings and therefore absolutely impermissible. It was contended that the pleadings do not refer to any such conversations which are sought to be proved. Therefore, this evidence has been wrongly accepted. Furthermore, the said compact discs are a clear-cut infringement and downright invasion of the wife's privacy. Thus, a violation of Article 21 of the Constitution of India. As the conversations have been recorded without knowledge, what to say of consent of the petitioner, the counsel argued. The counsel further contended that the family court has given a complete go-by to Section 65 of the Indian Evidence Act, because if recordings were done through a mobile phone, compact disc of the recording and the transcripts thereof in any case cannot be accepted as evidence. The counsel for the petitioner submitted that the husband, been very well aware of the conversations allegedly held years prior to filing of the divorce petition, was at liberty to have incorporated them in his pleadings at the very first instance. Though the veracity of such conversations cannot be vouched for, even if taken to be correct, they are not admissible in evidence as they have been recorded without the consent or knowledge of the petitioner, the counsel submitted. The counsel of the husband refuted of the arguments and submitted that there was no questions of infringement of the right of privacy. And in any case, the husband can always be subjected to cross-examination. It is vehemently argued that conversations so recorded are not beyond pleadings, as it has always been the husband's case that he was treated with cruelty by his wife. Though specific conversations are not mentioned in the petition, it has been clearly mentioned that the wife used to treat him in a cruel manner, his counsel argued. The recorded conversations are only an attempt to prove the same. Therefore, it cannot be said that they are beyond pleadings, the counsel argued. The High Court set aside the Bhatina's family court order.
Very well. Good. See, what we saw through Ekta today is the right of privacy prevails, not only in case of husband and wife, but all the people. See, if you are recording something without my knowledge, even if I'm your friend or I am your sister, or I may be something related, or maybe in a private way, you cannot record my conversation without my permission. And further, if you produce the same thing, it cannot be used. Now here it was a case before husband and wife, where there are many such cases which has come before the court, that what if there is a recording between husband and wife and it is without the consent, it cannot be produced before any court. One, because Indian Evidence Act does not permit such kind of evidence to be led. Thirdly, what is more important here, that if it is without my consent, see, if you do it with my consent, that I'm going to use what you are saying. If it is same thing is said in the premises, court premises, in the while I'm talking to you, The husband, wife, they say we are recording this consent and whatever we are speaking, then it can be put. Otherwise, it can never be produced. So always remember that whatever is recorded without the consent, it can never be produced. It is also an infringement of right to privacy. Now, recently under Article 21, right to privacy has taken also a right to life. That if I have something, I cannot be forced that my personal life is thrown outside without my knowledge. So it's a right to privacy will prevail. And under article, this is a protected that if I have spoken something and you have recorded without my knowledge, my right to privacy will be violated and court will come to my help. So always remember that anything which is recorded, nowadays we find so many divorce petition where compact disc CDs are available, mobile transcripts is also available. It cannot be done unless until there is a special permission in criminal matters where 65B's permission is required. Indian Evidence 65, if you read 65B, there is a complete procedure for this same. So always remember that if something is recorded without your knowledge, without your consent, it's a complete infringement of your right to privacy. Now next we'll be reading again a little bit of matrimonial research, but about the criminal matter. It is about the impounding of the passport. Now we all know that passport is issued by central government. If you ever just open your passport, you will find that there is a issued by central government. So passport is a central government property. Now there was a question few years back before the Bombay High Court, which said that passport is a central government property. The police authorities, which are the state subject, now here what happens that when the police authorities which works under the state government, do they have a right to impound this same? The court has answered it in negative that passport being a central government property, it can never be impounded by the state government without the permission unless there is a special reasons for the same. Now recently there was one this judgment which I would like all of you to read. Just a minute. It is from MP High Court. Can someone's passport be impounded merely because a case under section 490 IPC is pending or a red corner notice issued? MP High Court unravels. Now here the MP High Court has said this man was a travel blogger, agent, something of that sort. He was regularly traveling. His wife lodged a complaint under 490 IPC. Now what happened? His passport was actually for 10 years. And after some years, when he went for a renewal of the passport authorities were not renewing the same. They said there is a criminal case pending against you. Now, when there is a criminal case pending against you, it does not mean that uh, your passport will not be renewed. The police authorities has to give something in writing and also something very concrete that it will not be renewing your passport because there is a reason. Maybe you're a terrorist. Maybe there's a possibility that you may not be available for the trial. Now, here a lot of there are many judgments in this MP High Court judgment of the Bombay High Court and other benches also, which said that the passport can be renewed only subject to some condition. The police authorities or the passport authorities has to give a good reasons for not renewing the same. Just because of matrimonial dispute or some small disputes or one FIR is pending against you, that does not mean your passport will not be renewed. Many times we come across clients who questions us. If there is a criminal case, I will not be able to go out of India. See, we have Salman Khan's case where he used to travel for shooting purpose outside. So I have been given this example many times that if he can travel, other people will also be given a chance to go outside India for the maybe for the job purpose, maybe for some other reason. So always remember, passport is central government property. One, number two, unless until there is a concrete reason, the passport officer cannot refuse to renew your passport for a 10 years period, which is the general period. Maybe there is a possibility the passport authority may not renew it for may renew it for yearly, but that is in a special case, not in the regular cases. So always remember, passport can be renewed even if there is a criminal cases pending against you.